Okay, looks like we have both council connected as well as, so we'll go on the record. Hold on one second here. Okay, go on the record now in Lee versus Lee. This is file number 2419864. If I could just have both council put your appearances on.
Yes, thank you, Your Honor. Attorney Cal DeBrucker with and on behalf of the plaintiff, Renora Lee, and we both appear separately via Zoom today.
Good morning, Judge Elliott Blumberg on behalf of Timothy Lee, who's also appearing via Zoom.
All right, thank you. We're on the record today for a status conference in this file. I know we did at one point have a motion scheduled, I believe, on Wednesday regarding an order, a prior order that had been entered in light of, I believe, a CPS investigation, which is now concluded. But other than that, this was set for a status conference today. So I guess, Mr. DeBrucker, on behalf of the plaintiff, I would address you first, and if you could tell me where things are at, in particular in terms of any, the property division aspect of the divorce here.
Yes, Your Honor, thank you. I think, opposing counsel and I had some discussions regarding the asset and property division just before this case went on the stay per stipulation pending the CPS investigation, which has now concluded if the court's not aware. Hence the filing of our motion regarding parenting time, as well as lifting the stay. It doesn't appear that the parenting time motion hearing is necessary at this point. My client does have possession of the kids, is my understanding. But I do believe we still need to lift the stay. We did have a quick objection hearing on recommended support issues with the referee last week, and we anticipate new calculations coming from that, as well as a continued evidentiary hearing that we had started, I think, back in November of last year, Your Honor. So really, I think a lot of our focus has been on the custody and parenting time and the CPS case and things of that nature. I don't think there's a whole lot for these parties to divide. They have been separated for a couple of years now, I believe. So I don't really foresee any major issues regarding division of assets and debts. There's no real estate. I think it's probably getting some of the personal property items maybe that might be in dispute resolved.
All right, thank you, Mr. Blumberg.
Judge, I would agree only to the extent that there isn't significant assets to be divided. The real issue is the custody situation. Based on the CPS investigation and the removal of the children from the plaintiff mother, the kids have been in the care of my client for 9 months. She has been provided very limited parenting time during that time. The case was concluded based on the CPS's failure to comply with the court's scheduling order. There's never been any resolution or decision made on the merits. The allegations are serious. There are allegations of neglect, and those remain unresolved, just that the petition's been dismissed because of the failure of the attorney to file a witness and exhibit list. There were some procedural issues arising from that case, but in terms of the merits of the case, it's never been decided or heard. So I have grave concern about the safety of these kids being returned back to the mother. Again, they had been in the care for 9 months. So now with the reversion back to the old parenting time schedule and custody order, my client has very limited contact with the kids. And my understanding is that the plaintiff continues to reside in the home of the parties that were alleged to have abused these kids. So I think the property issues aside, we need to get this matter heard either before the referee or Your Honor, because the current arrangement causes significant concerns.
Okay. Has there been, are there any motions pending before the referee? What is the status?
I had filed an ex parte motion that the court denied. The court generally then would refer that motion to the referee, and I don't know that Your Honor did that. So I don't think there is any pending motions as of today.
All right, Mr. DeBrucker, would you agree that this this does need to be referred to friend of the court for a determination by the referee and then, potential further hearings after that.
Yes, Your Honor, I would agree that we do need hearings on the custody and parenting time
Okay.
and support for that matter.
Okay, so I'm going to issue a status conference order referring this to friend of the court to schedule a hearing on those issues. And then we'll proceed on that track. In terms of the property division aspect of the divorce, I'm not going to set any further hearings. It doesn't sound like that's something that's going to require a lot of court time to resolve. So that's how we'll go forward. And I will, again, refer it to the friend of the court, and the friend of the court will send out notice of hearing for those issues. Mr. DeBreaker, is there anything else we can address for your side today?
None on my end, Your Honor. Thank you.
Mr. Blumberg?
Judge, I don't mean to be difficult, but there are pending felony charges against Miss Lee in this county. And I know you perhaps are not in a position to make any findings, but the one that we are reverting back to, again, places these kids in her care and denies my client.
Mr. Blumberg's frozen on my screen. Just
Very little parenting time.
Mr. Blumberg, can you just repeat, you froze up there. Can you just repeat maybe the last minute of what you just said?
Sure. I don't know if it's on our end or not, but again, the referral by the court is appropriate, but the reality is we're not going to have an evidentiary hearing until in the fall. And again, I'm not in a position to ask the court to make any findings as to those allegations, but I would ask the court to at least be mindful of those allegations because there were at least substantial findings by CPS to place the kids away from the mother and in the care of the father. I don't know what safeguards the court can put on this situation today, but I would ask the court to at least give some consideration to that.
Well, I'm certainly going to request, and we'll put that in the order that friend of the court, schedule this for the next possible hearing date. Of course, the court is mindful of any danger to minor children. I guess, what I would note is that there's been allegations on both sides of abuse of these children. And so as I sit here today, it's hard for me to determine which side or whether both are being abusive or whether neither are. So I appreciate your statements, Mr. Blumberg, but certainly I think the same could be said of your client in terms of allegations. So, the court's in a position where we need to have some evidentiary hearings for the referee and potentially the court later to make findings based on the evidence that's produced rather than, allegations going back and forth between both parties.
I appreciate that.
So I think what I can do today in terms of that, absent, further ex parte or emergency motions, is to try and expedite it as quickly as I can to get the evidence in front of a fact finder.
Understood.
Okay, all right, thank you. So I will issue that order today. The friend of the court will get those dates out as soon as possible, and all parties on this file are free to disconnect at this time. And Mr. Blumberg, I know you have a 9:15 and a 9:45, but I do have a hearing in between there, so I'm just going to put you in the waiting room for just a moment.
Okay, thanks, Judge.
Thank you.
Okay, Ms. Robinson, are you able to hear me okay?
Yes, Judge, good morning.
Good morning, and I apologize. I know you requested to be taken right at 9. I didn't see that note until I was already into the other 9 o'clock, so I was not ignoring it. I just didn't see it in time.
I
so
appreciate it.
Otherwise, I would have brought you in first because there wasn't any other priority. But we do have the parties connected now on this file, which is Berry Hill versus Berry Hill. That is file number 2620441. We have Ms. Robinson present on behalf of Mr. Berry Hill. Ms. Berry Hill, I just need you to unmute yourself, please. Thank you. And Ms. Berry Hill, are you able to hear me okay?
Yes.
Okay, you're appearing without an attorney today, is that correct?
Yes.
All right, thank you. So we're on the record for a status conference today. Ms. Robinson, on behalf of your side, can you tell me where things are at in this case and what we would need to do for scheduling to get this resolved?
Well, I'm hoping that we can resolve this entirely today, Your Honor, because the parties are completely in agreement. We do have a signed consent judgment, and they are ready to do their pro confesso today if you are willing to allow it.
Okay, Ms. Berryhill, is that correct?
Yes.
Okay. You're coming through a little bit faint. I don't know if you could get a little bit closer maybe to whatever the device is that has the microphone.
All right. Can you hear me any better?
That's much better. Yes, thank you. So Ms. Berryhill, are you willing to go forward today with finalizing things?
Yes.
Okay, so I'm going to place both you and Mr. Berryhill under oath. If you both could raise your right hand, please. Do you both solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
I do.
Thank you. You can both lower your hand. And I think, Ms. Robinson, I'm going to have you, even though your client is the non-filing party, I'm going to have you take the statutory proofs from your client, and then I'll supplement that with testimony from Ms. Berryhill.
Thank you. Mr. Herbert Berryhill, please state your full name.
Robert L. Berryhill.
You are the defendant in this matter.
Correct.
Have you reviewed the proposed judgment of divorce, including the terms of the property settlement?
I have.
Do you understand that this judgment bars spousal support for both parties and this provision cannot be modified, meaning neither party will be able to seek spousal support in the future?
Correct.
Does the judgment fully dispose of all property and debt accumulated during the marriage?
It does.
Does it accurately reflect your agreement with the plaintiff?
Yes.
Did you enter into that agreement freely and voluntarily?
Yes.
Do you believe the judgment fairly resolves all issues between you and plaintiff?
Yes.
And I'll go back and ask some earlier statutories. When were you and the plaintiff married?
When? What year? I was gonna say January 2nd, 2015.
And how long have you been a resident of the state of Michigan?
My whole life.
How long have you lived in Otsego County?
12 or 13 years.
Were there any children born of the marriage?
No.
Is either party currently pregnant?
No.
Your Honor, does that satisfy the proofs for the defendant?
Maybe I miss it. Mr. Berryhill, do you have any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Okay. All right, Ms. Berryhill, did you hear all the questions that were asked of Mr. Berryhill?
Yes.
Did you hear all his answers?
Yes.
Do you have any reason to believe that any of the answers that you gave were untrue?
No.
Okay. Are you currently pregnant?
No.
And Ms. Robinson, Mr. Berryhill's attorney, has indicated that the two of you have resolved any issues regarding the division of any assets or debts of the marriage. Is that correct?
Yes.
Okay. You understand that you would have the right to have an attorney review that agreement if you wanted to, and that if you asked for that today, that I would give you time to do that?
Yes.
Okay. And are you still willing to go forward and finalize the divorce today?
Yes,
Have you reviewed that proposed judgment that Ms. Robinson referred to?
yes,
Okay. And do you agree to abide by all the conditions in that judgment?
yes,
And you understand that you would not be receiving any alimony or spousal support, and that means that you would be waiving that forever and that you couldn't come back later and ask the court for that?
yes.
Okay. All right. Ms. Robinson, did you have any questions for Ms. Berryhill?
No, Your Honor.
Thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce. Ms. Robinson, are you going to submit that today to the clerk's office?
Yes, Your Honor, we will get that over to you guys.
Okay. Ms. Berryhill, are you asking to have your last name changed as part of the divorce?
Yes,
Okay. And Ms. Robinson, is that indicated in the judgment?
Yes, it is, Your Honor.
Okay. So Ms. Berryhill, once I've signed that judgment, which will probably be either later today or tomorrow, your name will be legally changed. So you'll just want to make sure that you get a copy of that judgment, because when you change your identification and other documents, they're going to need to see that. Do you have any questions about that?
no. Oh, I take that back. About how long will it take before I actually have that paperwork in hand so that I can go back and change my name?
You can get it here at the clerk's office in Otsego County anytime after I sign that. I just don't know, when Ms. Robinson will get it here and when it gets on my desk to sign. So you can call the clerk's office to confirm before you make the trip.
Okay,
And we will serve a copy to
Yeah,
Ms. Berryhill as well.
Okay. Ms. Berryhill, did you have any other questions?
no.
Okay, Ms. Robinson, anything further from your side?
No, Your Honor, thank you.
Thank you. That's all for this hearing today, and all parties are free to disconnect. Since file. Okay, got council connected. We'll go on the record in file number 2620445. I'm not going to try that last name first, so I'm hoping one of the council can tell me the correct way to pronounce that.
I believe it's Hudzinski, Your Honor.
Okay, so this is Hudzinski versus Hudzinski. If I can just have both council put your appearances on, please.
Good morning, Elliot Blumberg on behalf of Ben Hudzinski.
Good morning, Your Honor. Joseph C. Fisher on behalf of Whitney Chudzinski.
Okay, and Mr. Blumberg, is your client there with you?
Yes, he is. He is.
Okay, great. And Mr. Fisher, I do have your client connected, although she doesn't have her camera on, but I have a Whitney C connected here. So she should be able to hear what's going on. This is set for a status conference today. Mr. Blumberg, on behalf of plaintiff, can you tell me where things stand and what we would need to do for scheduling to get this resolved?
I will certainly try. This is a fairly recently filed divorce case with no children. There are significant premarital assets that are being disputed at this point. We have not yet received the verified financial statement of the defendant. I think we've supplied them ours, but I guess we're trying to conduct some discovery to find out what assets are out there. So I would ask the court, in terms of a scheduling order, to give us 90 days to complete discovery. I think we would probably go to mediation at that point, and hopefully Mr. Fisher and I can resolve this matter.
Okay, Mr. Fisher?
With respect to the domestic relations verified financial information form, I thought we had sent that some time back, and I'll double check on that. If it wasn't sent, I'll make sure it gets sent promptly because it's been in my file for some time. I know that the plaintiff makes claims with respect to separate property based on a premarital purchase, et cetera. Some of that we agree with, some of that we dispute. We're getting appraisals done. There may be some appraisals required for personal property, but I would think we could get it done in the 90 days suggested by Attorney Blumberg. Thank you.
Okay, so if we had discovery open for 90 days, if we say mediation within 120, and then the court set this for a status conference at about 120 days, and then if things are resolved, we could use that as a date to take proofs and finalize things or set further scheduling. Mr. Blumberg, do you have any objection to those timelines?
No, I think that's appropriate. Thank you.
Are there any other dates that you would like to request today for the scheduling order?
I can't really think of any.
Okay, Mr. Fisher?
I'm fine with what we've done thus far. Thank you.
Okay, so I will put that into a scheduling order, send that out to both sides. The court will also set this for that status conference pro-con hearing in about 120 days. We'll send out notice of the date and time of that hearing. And that's all for this hearing today. Thank you. All parties are free to disconnect.
Take care, Joe.
Hey. All right, Mr. Backlund, are you able to hear me okay?
I can hear you, Your Honor. Yes.
Great, thank you. So we'll go on the record in Haskell versus Haskell. This is file number 2218880. If I could have both counsel put your appearances on.
Certainly, Zach Backlund on behalf of Aubrey Haskell, Your Honor, who it looks like is appearing by Zoom with us.
Good morning again, Judge Elliott Blumberg on behalf of David Haskell, who's appearing via Zoom from my office.
All right, thank you. We're on the record today for a motion by Mr. Haskell for the court to enter a judgment of divorce. I did review the motion. Mr. Blumberg, I had a chance to look at your proposed judgment. I guess, Mr. Backlund, I did not see anything, a written response from your side. I don't know if you filed one.
So, Your Honor, we had filed a notice of presentment with a proposed judgment. I'm hoping that's in the file in front of you. And then Mr. Blumberg filed his objection to our proposed judgment.
Okay, got it. All right,
So-
thank you. Yeah, okay.
Sure. So for our proposed judgment, Your Honor, I know we've been at this one forever, and the court granted leeway to us to try and reach a resolution regarding the issues. This is a case where the parties had two prior agreements on which we had a trial back in December of 2023. And admittedly, there are some gray areas in the language in those agreements. And so part of what we tried to do and reached very, very minor agreements on some of these things was try to address some of those issues so that, the parties wouldn't have to continue coming before you in the future. Unfortunately, we weren't able to reach some big picture agreements on many of this. So in our notice of presentment, we simply, on the plaintiff side, incorporated those agreements saying that they were part of the judgment. Without going further to, distinguish certain things. I know in the proposed judgment from the defendant side, it references, slight changes in the child support. For example, the parties in their agreement said that the child support was to start in March of 22. We hadn't had an agreement that it would start on a different date. I know defendant's proposed judgment has that starting in June, that $1,200 a month instead. I simply kept it the way that it was in the agreement. I know the spousal support was litigated briefly in front of this court as well. Whether or not Mr. Haskell would receive any credit toward his arrears was never resolved, understanding he could simply file a motion upon entry of the judgment to do that. There is also reference to the business interests, the DCH logging, which is Mr. Haskell's business. I understand the parties' agreement said that he would receive all the equipment for DCH logging, and I believe the defendant's judgment says he receives all business interests. Understanding, we're getting a little into the weeds a little bit, but I just wanted it to be consistent with the parties' agreement. There's also something in defendant's proposed judgment regarding a joint bank account going to Mr. Haskell. But the parties' agreement, and that may be an NAFCU account, which would go to Mr. Haskell pursuant to their agreement. But again, without adding those specifics or knowing exactly what that was, I simply kept it, pursuant to the parties' agreement. There were also some additional items regarding legal custody to which the parties had agreed. Those are paragraphs I through K in plaintiff's proposed judgment regarding the ability of the party's child to choose his religion or creed, if any, and providing plaintiff with the ability to make decisions regarding certain vaccines or, medical decisions regarding the child. And then just simply understanding that this has gone on so long and the proposed judgment, each judgment references issues that may need to be decided. I know defendant's proposed judgment indicates it's the last pending claim before the court. In our plaintiff's judgment indicated that there were other things that may need to be resolved or issues that may be reserved, understanding that arrears are certainly going to come up, and there are also issues related to the marital home, which Ms. Haskell wanted me to address as well. There have been myriad repairs done or work done on the house since 2022. And that's one of the bigger issues, is interpreting the language in the parties' agreement. Miss Haskell has been living in this house that has had certain repairs done, starting in the 2022, where there's been some leaks and some damage to the house, and some of the siding used is soaking up water, and, that's rotting and causing mold. And again, there's been the issue of, okay, well, are these things that Mr. Haskell is paying for, part of the support when he hasn't been giving her cash, but, paying for certain things, and then she's not able to make these repairs on the house? It's unclear in the parties' agreement, the timelines perhaps. We wanted to avoid arguing in the future over those things. Again, to just capture this all, plaintiff's judgment, proposed judgment, uses the agreements without trying to go beyond those agreements, aside from what was agreed to in court, of course, regarding the custody and the parenting time, and then the issues that will need to be resolved in the future, Your Honor.
All right, I'll ask for your input in just a second, Mr. Blumberg, but I mean, Mr. Backlund, are you saying, number one, you want the court to enter your version of the judgments? Outside of that, I mean, is the second solution for the court to take both judgments in the court to decide what is the appropriate language from either or both?
Yeah, I suppose, Your Honor, because again, we had the trial on the agreements, and we've tried to mitigate the problems that we see, coming down the pipe with some of the language. And so I suppose if the court were to compare the judgments and ensure that, they match the record and the parties' agreement, I think that would be an appropriate manner to enter these judgments. Our hope is to get something entered, Your Honor. These parties need to be divorced.
Right. Okay. Mr. Blumberg?
Judge, I think while the second of your proposals, if those were proposals or suggestions, I think would place a burden on you and would be very time consuming. Believe me, both parties want these judgments to be ultimately signed and these parties divorced. We acknowledge, both Mr. Backlund and I, that there are still issues that the court will have to address post judgment. I think we both acknowledge that. While I say that, and I desperately want a judgment entered, I think that if Mr. Backlund and I sat down in the same room, we could hammer out the language that's appropriate. The biggest concern we have with the plaintiff's version is that it references agreements that have been either resolved or ruled upon by the court, and that a placement of the agreement in there is inconsistent with what actually happened. So I don't know Mr. Backlund's schedule, but I have blocked off in my own schedule 2 or 3 hours to sit down with him to hammer out language and ultimately resolve those issues that we talked about that needed to be resolved post judgment. So I appreciate the court's willingness to compare the two, and you decide what's the appropriate language. Again, given the time I think that's going to take, it would be a burden on you. I think a better way would be if Mr. Backlund and I sat down, and if we could at least limit those provisions that are at issue, then you could decide.
All right. So here's what this is what the court's going to order as part of the hearing today. The court is going to allow the parties, the attorneys, 30 days to confer, to try and agree on language. I'm not going to schedule any further hearings. If the court does not receive a consent judgment, in other words, one that's agreed, where the parties have agreed on the language within 30 days from today's date, and I'll put that into the order for today as well, then the court will enter a judgment based on the submissions of both parties, and the court will either adopt completely one side or the other, or the court will fashion a judgment incorporating one or more provisions from both judgments. But either way, that gives us a date certain that your clients aren't going to have to expend any more time or money appearing for hearings, and then we'll have to go from there. So I will put all of that into an order and get that out to both of you, and that's how we'll go forward. again, I think that gives you another opportunity to try and come up with language everybody can agree on, but it also gives your clients a time certain that a judgment's going to be entered one way or the other, and then to the extent we need post-judgment proceedings, we'll have to do that. Mr. Blumberg, anything further on this case today?
No, Judge, thank you.
Mr. Back.
No, thank you, Your Honor.
Okay, all right, thank you. And Mr. Backlund, you and your client are free to disconnect. Mr. Blumberg, if you'll stay on, I'll bring in the other 9:45 parties here.
All right. I'm gonna try to schedule a meeting for us. Okay. Oh, us or? Oh, maybe. Yeah. Thanks.
Judge, do you have that file?
Yes.
Okay.
Okay, Mr. Brecker, are you able to hear me okay?
Yes, Your Honor, thank you.
Okay, we'll go on the record now in DeGrasse versus Dash. This is file number 2419634. If I could have both counsel put your appearances on in this file, please.
Your Honor, Attorney Kyle DeBrucker on behalf of Rebecca DeGrasse. We both appear via Zoom separately today.
Thank you.
Good morning, Elliot Blumberg on behalf of James Dash.
Okay, thank you. This is set for hearing today. Number one, we have the set for a status conference. Number two, Ms. DeGrasse, through her counsel, has filed an objection to an order that was entered by the referee back on July 1st. We've had a chance to review that objection along with Mr. Blumberg's response to that objection. And so typically, Mr. Breicher, what the court would do at this hearing, although I think we've got some threshold issues that we're going to need to address, would be to, I kind of treat these as a pretrial type hearing because this is my motion day, so I don't have evidentiary hearings scheduled for this date, but the court would set it for an evidentiary hearing at a later date with input from both sides as to the amount of time that we would need and how many witnesses and so forth. But my understanding based on your response, Mr. Blumberg, is that it's your position that the court should not even allow a de novo hearing based on Ms. DeGrasse's failure to appear at the referee hearing. Is that a fair statement of your side?
Yes, it is, Judge.
Is there anything you wanted to say in support of that today?
Well, not only, again, was this the first time Ms. DeGrasse failed to appear for a hearing, she had filed an earlier objection on another referee ruling. We had a hearing scheduled before, Your Honor. She failed to appear for that. She's been held in contempt now, I believe, 3 times. Referee legal recommended and imposed 3 days of jail for continued denial of parenting time. And I think the front of the court documents clearly establish right in the second page that failure to appear for a referee hearing, one loses their ability to file an objection. So I think given that history, the denial of this objection would be appropriate.
All right, Mr. DeBreicher, what's your position on that?
Well, Your Honor, first of all, my client simply tells me she didn't get the notice of the hearing. Your Honor, we filed specific objections and requested the de novo judicial hearing, and although that right does exist regardless of whether she appeared before the referee on that hearing, like I said, she simply says that she didn't get the notice and therefore had no opportunity to testify, cross-examine, all those good things. And following what appears to be an hour of testimony from defendant alone, the recommendation, which has interim effect, completely altered the ECC, including the sole legal and primary physical custody aspects of this case. It permitted relocation, substantially reduced my client's time, and of course imposed a three-day jail sentence. We acknowledge, any prior contempt history does not eliminate her right to have present allegations heard by the court, nor should incarceration be enforced before the court can I suppose, independently review the contempt issue at the de novo hearing. My client is prepared to present evidence regarding the established custodial environment, domestic violence and safety allegations. And ultimately, Your Honor, this is not a simple parenting time motion. This is a complete change in custody and parenting time where my client has all the parenting time. Now she's, I think, limited to about 3 weeks, um, other than holiday time. So, Your Honor, I mean, my client does acknowledge that my client acknowledges that was a very important hearing, and she acknowledges that she would have liked to be present. However, she just states that she simply didn't get the notice.
All right, I have a couple questions. What's the status of the custody of the child now? Because that's not clear to me based on the filings.
Judge,
Your Honor,
I'm sorry, who are you directing that to?
Sorry, I should have said that, Mr. Blumberg.
Judge, based on the referee's ruling, custody has been physically changed to my client. There is also a felony parental kidnapping charge against Mr. Grez that's pending. When the law enforcement went to enforce referee legal's, in fact, your order, she took off with the minor child and fled. She was finally found and arrested. So physical custody resides with my client.
Your Honor, I would disagree with that classification. My client did not flee simply because she wasn't home at the time the order was supposed to be enforced. But
Well,
dad does have the child.
where is are you saying charges have been authorized, Mr. Blumberg, and in what jurisdiction here in Otsego County or somewhere else?
I think it's Otsego, but it may well be Oscoda County, as Mr. Grez was residing in Oscoda County. But as I give more thought to it, I think it's out of Otsego County.
Your Honor, I do believe it's Oscoda, if I'm not mistaken.
Okay. Mr. DeBreaker, has your client been arraigned on those charges yet?
I believe she has. She is released on bond currently.
Are there any bond conditions that deal with her ability to have contact with the child?
Your Honor, I believe she just was released on Friday. I don't have that information regarding bond conditions currently.
Well, I mean, I guess I'm going to assume in a case where that's the charge, there's going to be a bond condition prohibiting your client from having contact, I would think. Okay. I'm going to ask counsel to just remain here connected for a minute. I just want to see if I could get some more information on the bond conditions from either Oscoda or Otsego County. I'm not going to take a lot of time because I do have to go forward with the docket. But if everyone could just remain on the line, I'm going to put you all back in the waiting room, and it'll just be a couple minutes. Okay, we're back on the record in file number 2419634. I don't think the case is in Otsego County. We tried to find a record in Otsego County District Court, and at least in the short time I had to look, I couldn't find that. So I believe it's in Oscoda County most likely, but so I'm not able to see what the bond conditions are. But either way, to address some of the issues that have been raised here by the parties. Number one, I took a close look at the file and the orders that have been issued over the past month or so since July. And it appears, as well as the file in general, and kind of what's gone on over the past 6 months or so in this case. And so there's a couple of things that I think are noteworthy in terms of the court's determination about how to proceed. Number one, I think there were two issues raised at the July hearing, and that one was a motion to change custody and the other was a parenting time violation. And when I read the referee's recommendation with regard to custody and the referee's findings with regard to parenting time violations and contempt, which the custody part of it, the court did not sign an order adopting the custody part, but did sign an order dated July 2nd adopting the findings regarding the parenting time violation. And so the language regarding interim effect, in my view, and my reading by the referee, all refer to the penalties, for lack of a better term, for the parenting time violations. In other words, that the defendant would get custody for the remainder of the summer as a make-up parenting time thing, and that was given interim effect. There isn't any language in the recommended order by the referee giving interim effect to the change of custody. I don't know that as we go forward here that's a difference that, or a distinction that makes a difference, but I think it's important to point that out. So, you know, when the court looks at Ms. DeGrez's objection based on the interim effect, number one, looking at MCR 3.215 G3, which was cited, does indicate that the court can't give interim effect to changes in custody by administrative order. In other words, the court can't issue a blanket order that any of those things are just automatically given interim effect. It doesn't say that the court can't, on a case-by-case basis, give interim effect to changes in custody. So to the extent that the remedy for the parenting time violation, in other words, giving the defendant parenting time for the remainder of the summer of 2026, to the extent that that does result in a change of custody, the court finds that there isn't any violation of the court rule or anything that would prohibit that from having interim effect, because it's not resulting from a blanket administrative order by the court, but rather individualized finding in this case based on the referee's recommendation and findings that was an appropriate remedy. So the court finds that there isn't anything procedurally improper about giving interim effect to that portion of the order as objected to. So I'm denying that objection for purposes of the record. Then the issue is the defendant's argument regarding whether or not the plaintiff is entitled to a de novo hearing at all. I appreciate, Mr. DeBrey here, yours and your client's position that she didn't receive notice. The file reflects that she was provided notice at her last known address. If she has not updated that with friend of the court or with the court clerk, then that's something that's, on her end. The objection references some kind of health issue along with not receiving notice. So I don't have any documentation supporting that there was some kind of health issue that would have prevented her from attending that hearing. I also think that, to me, suggests that, when you have two kind of excuses for not making a hearing that are mutually exclusive, in other words, she either didn't know about it or she couldn't attend because she had a health issue. It can't be kind of both of those at the same time, or, it's hard to argue those two things as alternate theories for her failure to appear. So I find that troubling. I'm not sure that I find Ms. DeGrasse failure to appear for that hearing to be for a good cause based on either a health condition, which I have no documentation of, or that she didn't receive notice when there's no indication in the court file that her notice was returned to the court as undeliverable or something like that. And, you know, kind of making those two excuses at the same time, to me, undermines the credibility of any excusable failure to appear for that hearing. I also have to take note of what's gone on prior to that, which is multiple failures by Ms. DeGrasse to appear. She filed an objection to a previous order by the referee. The court set that for hearing on February 2nd of 2026. She failed to appear for that hearing. The court reset it for March 2nd of 2026. She failed to appear for that hearing. And those were, again, not things that the court was ordering her to appear for. Those were dates the court set at her request. It appears to me that there was a hearing set in front of the referee or held in front of the referee on May 27th of 2026, where the scheduling was set for the July 1st hearing. The referee's order there seems to indicate she didn't appear for that hearing either. So it just refers to the defendant and the defendant's attorney appearing for that. Also, you know, there were requirements put in place, not only that she appear for the July 1st hearing, but to exchange witness lists and comply with other procedural requirements, which the defendant did. And along with not appearing for that hearing, the plaintiff did not either. So I guess not having, if she didn't have notice, I guess that would excuse that. But if it was based on a health issue, there's no reason why she couldn't have or wouldn't have submitted those kind of things prior to the hearing in preparation for that hearing. And then if she couldn't attend because of some last minute health emergency, you know, again, those things just don't, it's not all adding up. And all of that on top of the fact that the purpose of a de novo hearing and the right to a de novo hearing is where both sides appear, they present evidence in front of the referee. The referee makes factual findings, and one side or the other doesn't agree with those findings and wants a judge to make a determination based on that. I don't think in a circumstance like we have here, where the defendant has appeared all along for every hearing, was ready to go with witnesses, had supplied witness and exhibit lists in advance of that hearing on July 1st, was there ready to present evidence and did present evidence. And where the plaintiff has a history of non-appearing for hearings, doesn't appear for that hearing, and essentially allows the plaintiff to skip the entire referee process, to me is not the purpose of the right to de novo hearing. And so if this was a situation where that was the only hearing that the plaintiff missed and she had otherwise complied, I think there would be room for a finding of good cause and either to refer it back to the referee for a hearing or to have a de novo hearing in front of the court. But again, this is more than just that. I think there are multiple factors here. And then that's to say nothing of Ms. DeGratte's failure to comply with the court orders and to be currently charged with parental kidnapping on top of all of those other things. So all of that taken together, again, the court provides a basis for the court to find that she's waived any right at this point. I simply think it would be unfair to allow her to engage in this entire course of conduct going back to February of this year of not appearing, of not seeking to address her own rights in this case, and then at the very end, after the defendant has complied with everything, now seeking for another hearing. So again, based on the entire course and sequence of events, including what's happened since that July recommended order was put in place, the court is going to deny the objection in its entirety. And Mr. Blumberg, I would request that you submit an order to the court reflecting that ruling. And Mr. DeBreicher, to the extent that, I guess I would just say it'd be up to you from that point forward to address any other legal procedural rights Ms. DeGrasse may have to challenge the timing of the court here today. So,
Understood.
the court's not going to order any further proceedings. The order from July 1st of the referee will be given effect. The court will, Mr. Blumberg, if you can include in your order a statement indicating that the front of the court should draft an order for the court to sign.
I can do that. I just want to make sure we're all on the same page. If the objection has been denied, that means that the referee's recommendation becomes the order of the court?
Correct.
Okay. And again, I don't mean to, I guess I just want a little clarification. Given that the referee took testimony and made a recommendation that custody should be changed, does that mean that at the end of the summer, the defendant continues to have physical custody of the child? Right.
So that order will go into effect because the court is denying the objection to that, to all portions of the referee's findings from July 1st.
I understand. Thank you.
Okay, thank you. That's all for this hearing today, and all parties are free to disconnect at this time.
Thank you.
See that tall, of course. All right. Counsel, can you tell me how to pronounce your last name, please?
Ricich, Your Honor.
Okay, Mr. Ricich, I've got a lot of people in my waiting room. None of them are matching what I have on my notice of hearing for other counsel. Do you know what other attorneys might be appearing in this case? Because I don't see Mr. O'Brien or Ms. Osborne, but they may have someone else covering.
I believe Melissa Hagan is covering for Ms. Osborne.
Okay, got her.
I don't know if there'd be anybody else other than Mr. O'Brien. He's the only one I've ever talked to about this case.
Okay, let's see. How about Kyle Glazer? Is that possible?
Maybe I'll have to check the pleadings. Give me 1 second.
Okay.
I don't think I've ever seen anyone other than Bob on any of the pleadings. I'm not sure if he's entered an appearance. Bear with me 1 second, Your Honor.
Sure.
No, Bob's the only attorney that we have on our caption that I have on any pleading.
Mr. Glazer, can you tell me what case you're appearing on, please?
Good morning, Your Honor. I'm here on MDC Contracting v. Mason Brothers Concrete. Case number
okay.
ends. Okay.
1 second. I'm just going to put you back in the waiting room for a second.
No problem.
Your Honor, would you like me to try to call Bob's office and see if he's...
Sure. Let me Yes, that'd be great.
Okay.
Thank you.
All right, give me 1 second.
And Your Honor, not sure if it matters too much, but I am here for MDC rather than Mason. Not sure if that matters for the naming.
No, I just put something in there to, so I knew
No
what
problem.
case it was. That's not official. I'm not gonna hold me to it. Okay, so Mr. Glazer, I'm gonna put you back in the waiting room for right now. I have someone connected on a Samsung device. Ma'am, can you tell me your name, please? I just need you to unmute. I need you to unmute first, please.
Amanda Peters.
Miss Peters, okay. What case are you appearing on?
I guess it's Amanda Paul.
Oh, Miss Paul, okay. Gotcha.
Yes.
Okay, I've got one other matter I have to take before your case, so I'm just gonna put you on hold for just a minute, okay?
That's okay. Thank you.
Thank you.
Judge, is this one or Otsego case?
This is Wexford.
Okay,
Sorry.
sorry. No, it's okay. I was like, panic.
Ms. Hagan, we'll get started in just a minute. I've got a bunch of people in my waiting room that don't have identification, so just trying to figure out who everyone is.
No problem.
Sir, that's signed in under Zoom user. Can you tell me your name, please?
Bill Mason.
Mr. Mason, okay. We're gonna get to your hearing in just a minute, so I'm gonna put you back on hold.
Okay.
Ma'am, can you tell me your name on the iPhone, please?
Kimberly Stilson.
Stilson, okay. Okay, ma'am, it's gonna be just a minute and I will call your case in just a minute. I'm gonna put you on hold for a little bit here, okay?
Yep.
Thank you. Mr. Rasich and Ms. Hagan, I'm just gonna take a couple other matters while we're waiting on your case here.
Yep.
Hi, Carolyn. This is Bo Reisich calling from McGraw-Morris regarding Lawrence versus Lake Mitchell Sewer.
Okay, Mr. Paul, if you can unmute, please. And we'll go on the record in Paul versus Paul. This is file number 2620433. The record should reflect we have both parties connected. All right. And this is set for a final hearing in this case. I don't have a judgment of divorce, but what we can do is I can take the testimony from each of you that I need to take if we have an agreement. Ms. Paul, as the plaintiff, are there any matters that are still in dispute between you and Mr. Paul?
No, I have not really spoken to him the last 3 years.
Okay. Did we have a hearing in this case last month?
Yes.
All right.
Yeah. 7-6, set the final hearing, court explains to get judgment of divorce and submit to clerk before final hearing.
Okay.
Yep.
Ms. Paul, is there a reason why you weren't able to get that judgment submitted?
I didn't know I had to do that. I didn't get anything in the mail. I didn't know if I was supposed to do something.
That's the note that you went through. But it, explain. how
Yeah,
to
so
get
at
that.
our hearing last month, I kind of went through it with you and explained to you what you needed to do
Okay.
so that we could get this finished today. And,
Okay. Okay.
What
Okay.
I said was, if you didn't get it submitted, we were all just gonna have to come back. We wouldn't be able to do it. So,
Oh, shoot. Okay. All right.
please get that done. I can't finalize, I'd love to finalize your divorce for you, but there's that final document, the judgment that I have to sign before I can do that. And if I don't have
So-
that,
How do I do that?
well, you have to go wherever you got your forms to file for the divorce. I don't know
County
if you went
clerk.
online.
Okay.
You need to go online. It wouldn't have been from the county clerk because they don't have the judgment forms here. So you're gonna need to
Okay.
get that form. If you go, there's a legal help website that walks you through the entire process. It's very easy to navigate if you go to that.
Okay.
All right, and then the court will set it for another hearing next month. Mr. Paul, did you have any questions at all?
No.
Okay. All right, you're both free to disconnect at this time. Thank you.
Thank you.
Usually I go through it.
Yes.
I have to say that I did.
No,
I'm sure.
I put it in there. Yeah.
Okay, Mr. Ricich, were you able to get a hold of Mr. O'Brien?
I called all the numbers at Miller Johnson that I know, including Bob and his assistant in the main line. I had left a message with his assistant, and so far, no, I didn't talk to Mr. O'Brien, so I don't know where he's at.
All right, well, how do you guys want to go forward today? I mean, we can, I guess, this is a Wexford County case. I'm presiding over this, and let's go on the record now while we're doing it. This is Wexford County file number 2531873, Lawrence versus Lake Mitchell Sewer Authority. And I'll just ask the two of you to put your appearances on today, please.
Good morning, Your Honor. Bo Ricich on behalf of the Lake Mitchell Sewer Authority.
And Melissa Hagan on behalf of Wexford County.
Okay, and we're missing Mr. O'Brien. So can you guys just tell me a little bit, again, I'm presiding over this case. I don't get a whole lot of detail, when I'm assigned a case like this. So maybe you can kind of give me an outline of what the case is about and what we might need to do for scheduling to get this resolved.
Sure. Happy to give you the 30,000-foot overview, Your Honor. The Lawrence's own property adjacent to Lake Mitchell in Cadillac. This case was filed back in early 2025. The claims are essentially that there is a force main, which is part of the sewer system for the Lake Mitchell Sewer Authority, that goes underneath the Lawrence's property. They claim that it was installed not pursuant to any form of easement. Lake Mitchell Drive back in the early 2000s was originally platted in the 80s anyways, a little bit further to the west. When the people of the Lake Mitchell area began to develop that platted subdivision, Lake Mitchell Drive actually was essentially installed a little bit further to the east than where it was platted. It's my position that the force main at issue here was installed within the originally platted right-of-way of East Lake Mitchell Drive. And then about 30 years later in 2001, that roadway was vacated and moved about 40 feet to the east. And so now we have where the originally platted roadway, the force main is installed there, but the road itself is moved about 40 feet to the east. The Lawrences own residential property and are attempting to construct a home, and the footings for that home intersect with this force main. And so it's essentially a property dispute regarding whether the LMSA had any sort of interest that would allow them to locate that force main in its particular position. I'll let Ms. Hagan chime in briefly here in a moment, but we brought in Wexford County on a third-party claim because when this sewer system was installed in the 70s, it was originally installed by Wexford County and then was ultimately deeded over or transferred to the LMSA in the mid-2000s. And so we brought in Wexford County on a third-party claim. The parties have, this case has been somewhat long in the tooth. The reason that it is my insurance policy for the LMSA is an eroding policy with a $100,000 sublimit. So every dollar that I spend on defense costs erodes what is available to try and resolve this case. I think that if Bob was here, and I think Melissa 100% agrees with me, that this case is screaming for a negotiated resolution to try and get this case resolved. So far, we haven't been able to do that. But again, every dollar I spend on defense erodes what little I have left to try and spend on a settlement of this case. So we facilitated back in, Melissa, what was it, April?
I think so. Yeah. Sounds right.
We facilitated back in April. We've continued to engage in negotiations since then. We haven't been able to bridge a gap, and now we're coming to the point where we're going to have to start working up discovery, written discovery and depositions. And then ultimately, Your Honor, I expect that all three parties are going to file dispositive motions for this court to resolve. It's my understanding the reason why Judge Elmore recused himself. I believe he's a owner of property along Lake Mitchell, and he may be a service user of the LMSA's system. So that's why I believe he recused himself. So that's the 30,000-foot overview of where we're at.
All right, Ms. Hagan, anything you wanted to add?
Well, my clients here, based on some indemnification and breach of contract claim, our defenses are essentially the breach of contract claim is barred by the statute of limitations, and a county cannot indemnify anyone. It's any attempt to do so is void under the Constitution. So we think that we're in a position to file a dispositive motion today, but I agree with Bo that this case really does call out to be resolved, and unfortunately, the plaintiffs haven't been willing to do that. I think perhaps if their damage claims were resolved, they might be a little bit more interested in negotiating. We believe, I think Bo and I both agree on this, that their money damage claims are barred by either governmental immunity or the statute of limitations. So no tort claims against governmental immunity, against governmental entities, sorry.
Okay, so, I mean, how much discovery would need to, those all sound like legal, legally based motions for your dispositive motion. So how much time, I mean, Can we
Well, we
set some
discussed-
dates for some of those motions that are based on legal issues, not factual issues?
I think that would be beneficial. So as a little bit more discussion of the settlement posture, Your Honor, like let's set aside the damages claims for a minute, and let's say, that's if that's not an issue, the cost to remove or move the force main from where it's currently located to Eastwood, it's around $225,000. And we're trying to come up with a pot of money to get this thing resolved. But ultimately, that pot of money is going to have to include funds from the plaintiffs. And that's where things fell apart at facilitation and in subsequent negotiations. So what what Melissa and I discussed this morning potentially was, as one last attempt before we get into and burn through a significant portion of what I have left to throw into settlement discussions, would the court be willing to entertain a settlement conference to see if we can have a conversation, get everybody here together, and see if, it didn't necessarily work at facilitation, but I think when the court gets involved, sometimes maybe parties will listen more so than they will at a facilitation. If that doesn't work, then so be it. We'll file dispositive motions. If we need to do discovery, I think 30 days would be fine. We have discussed, Bob and Melissa and I know I want to depose the two plaintiffs, and Mr. O'Brien wants to depose one representative from the LMSA. Melissa, I don't know if you want to take any depths. I don't think I need to of folks on your side. But we had discussed scheduling those depositions later in August. So if we don't do a settlement conference, I think a 30-day extension to discovery would be fine. But if the court is willing to entertain a settlement conference, I'd like to get that set up. And then if that fails, then let's set dates. And if we could have one date certain for dispositive motion practice, and have all of the competing motions heard on one day, I think makes a lot of sense.
Did the parties do like a mediation brief for the facilitator?
Yes.
Yes.
All right, well, I guess this is what I would propose. And then I'm going to build something in. Oh, Mr. O'Brien.
Oh.
Oops. I see him now. Mr. O'Brien, are you able to hear me okay?
I am, Your Honor. Sorry I'm late.
Okay, that's all right. We kind of have been discussing a way to go forward here, and then I was going to put in the order that give you 14 days to object if you disagreed with anything.
Okay.
But now that you're here, we don't have to do that.
Yeah.
But essentially, counsel just gave me some basics of what the claims are here regarding this force main that exists underneath your client's property. And so what they are suggesting is that there has been a facilitation. They're suggesting that, or asking the court to conduct some type of a settlement conference amongst the parties, an in-person thing. It sounds like everybody filed a mediation brief with the facilitator, so I just would ask the parties to give me copies of that. I don't need any of you to expend extra money changing anything to that if you don't want to. And then a time for me to come over there to Wexford. We can all meet in the courthouse and spend some time to see if there's a way we can get it resolved. And then if not, then setting a dispositive motion schedule and kind of going forward from there. What are your thoughts on that, Mr. O'Brien?
Yeah, I think that makes sense, Your Honor. And I think because we're all coming from different places, we could also do it at your courthouse too.
Mm-hmm. Yeah.
Okay.
If that's more convenient for you.
Okay. That's good. I mean, having that option, I have a 3-county circuit, so sometimes it's hard because the other judge has time booked here. But it's nice that here's what I would propose. I would like to set that date within the next 60 days so that we don't delay things any further. So I'm going to first look at having it here in Otsego if everybody's willing to come here. And then second option would be there in Wexford. And then we'll have that. If the parties we're able to get it resolved, that's great. If not, then at that settlement conference, we'll set dates for going forward from that time. Do you have any objection to that, Mr. O'Brien?
I do not, Your Honor.
Okay, Mr. Reisich.
No, I think that sounds like a great plan, Your Honor.
Okay, Ms. Kagan, any objections?
On board with that.
Okay, is there anything that any of you want? Oh, and then I'll just ask that you submit those mediation briefs to my office here in Otsego County at least 14 days prior to that date, whenever we get that.
One question, Your Honor, in terms of my claims attorney, is it okay if they attend remotely, either via phone or, again, the pot of money in terms of what they have is known, and there isn't any more than it. So I don't know if you'd be asking them to fly in. I will have my client representative from the LMSA there in person, but would you be okay with my claims rep being attending remotely?
Mr. O'Brien or Ms. Hagan, do you think that that would hamper settlement in any way for that person to be remote?
No.
I don't think it will. I think that's fine.
Okay, then I have no objection, Mr. Reisich.
Thank you, Your Honor. And then while we're here too, Bob, I have outstanding discovery requests to Mr. O'Brien. If we're going to do a facilitation or another settlement conference, I'm fine with holding off on the answers of those until we see if we can get this thing resolved.
No, that's fair. And I think with depositions too, we'll just hold off on those until after the settlement conference.
Perfect.
Okay. All right, so my office will work with Wexford to get that date. We'll send notice of all of that out to the parties. I'll also send out a status conference order reflecting what we discussed here today. And that's all. Thank you. Everyone's free to disconnect at this time.
Thank you, Your Honor. And
Thank you.
I appreciate your patience with me this morning.
Certainly.
All right. Bye-bye, everyone.
Still some. Okay, Mr. Stillson, if you can unmute, please.
Can you hear me?
I can, thank you. And
Oh,
we have
okay.
Ms. Stillson. We'll have Ms. Stillson connected as well. So this is file number 2620446. Stillson versus Stillson. The record should reflect both parties are present today by video. Thank you for your patience. The court's docket's running a little bit behind today, so appreciate both of your patience. This is set as a pretrial hearing today. This is where the court tries to determine whether there are issues regarding the division of any assets or debts that the court would need to set hearings to decide, or whether you both kind of agreed on everything. Mr. Stillson, you're the filing party here.
Yeah.
Do you feel that are there things that the court has to decide in this case?
No, not at all. I think when I did file, I don't know if there was an option, but I took it upon myself to take, most of the debt and let Kim not have to worry about that because of the kids and whatnot.
All right, Ms. Stillson, what's your view? Do you think things have been divided up?
Yeah, we've been pretty kosher between the two of us, trying to split things with our property and what have you. So we keep the boys because we have 3 boys that he's the stepdad to, and we're trying real hard to keep it very just mature and what have you, so that they don't, because this is the only home that they know, and I may be moving and or may not be moving. So we're just trying to make it easy on them. So yeah, we're just trying to split it to where they have access to the property and hunting or whatever it has you. So it doesn't seem we're arguing much about assets and what have you.
Okay, so, and I just want to clarify that those children were not born of this marriage, though.
No, sir.
Okay, and I only asked that because that's
It's part of it. Yes, sir.
different. Okay, so Mr. Stillson, then what we could do is set this for a final hearing where the court would take the testimony I need to take from each of you to finalize the divorce. There's one final document, Mr. Stillson, as the filing party that you need to submit to the court prior to that hearing. That's called a judgment of, it's called a judgment of divorce, and you can get that form where you've got your forms to file for the divorce in this case. So I'll need you to fill that out. Again, it's called a judgment of divorce. I'll need you to fill that out and submit that to the court before that next hearing.
Okay.
That is the final document that the court signs to finalize the divorce. So it's very important that you follow through with that step again before that next hearing. Otherwise, we'll just have, we'll have to reset the hearing. I won't be able to do anything for you on that date. So make sure that you submit that to the clerk's office here in Gaylord prior to that next hearing. The court will send notice of that to both of you. It'll be by Zoom, just like we're doing today.
Okay.
Do you have any questions about that, Mr. Stillson?
No, it's just judgment of divorce, correct?
Yes.
Okay.
Okay. Ms. Stillson, did you have any questions?
No, sir.
Okay, thank you. That's all for this hearing today. Again, look for that notice in the mail, and we'll go forward at that next hearing. You're both free to disconnect.
All right, thank you.
All right, thank you. We're on the record now. This is file number 2520171, MDC Contracting versus Mason Brothers Concrete. If I could have both counsel put your appearances on.
Good morning, Your Honor. Kyle Glazer, P88827 on behalf of the plaintiff.
Good morning, Your Honor. Hob Engelson for Mason Brothers Concrete.
All right, thank you. We're on the record today. We've got a motion for entry of a default and the dismissal of a counterclaim. And I did receive that motion as well as the response. I did not realize this before, but I do want to just disclose this now that we're all on video. Mr. Mason, I just want to confirm for the record, we've worked together volunteering for the St. Mary's Fish Fry. Is that correct?
Yes, Your Honor.
Yeah, okay. I didn't realize if that was you or not. And then when I saw you on video, I'm like, okay, I know this person. So I just wanted to disclose to counsel, over the years, Mr. Mason and I have volunteered together at various church events for the fish fry over at St. Mary's. So we've had a lot of interactions during the course of that. We have never really socialized or anything outside of that, but I want to disclose that to both counsels so that everybody's aware. I don't know that it's a reason for me to disqualify in this case, but to the extent that either of you want to address that at some point, I would certainly be open to any kind of motion on that. Other than that,
objection, Your Honor.
Mr. Glazer, how did you want to proceed? Did you have any additional oral argument you wanted to make today?
On the motion pending today, or on the what you had just mentioned with the interaction with the defendant?
Either one.
On the, as far as the interaction with the defendant goes, I have no oral argument on that. I'm going to be completely frank with the court. That's a decision that gets rung up the flagpole. If we have any issues, we'll file a motion on it, but I don't anticipate it being a problem for us.
Okay, and certainly I won't hold you to what you're saying today. If you take this back to your client and they feel that there's an issue, I'm certainly open to a motion later on.
No problem.
Okay, then as to the pending motion for today.
So as far as the pending motion for today, I do see on the register and act of actions a response was filed. I haven't gotten a copy of the response yet. I'm sure it's somewhere in the mail. Not quite sure where it's at. Seeing as though this is also set for a show cause, I would request, if the court's okay with it, if defense goes first on this one and I have an opportunity to respond to it.
Sure, I think that's fair. Mr. Ingleson?
Yes, Your Honor, we've dealt with one of the other members of that law firm, Lee Meldy, and we emailed our response to him because he attended both mediations, and I've never had dealings with this counsel, so that's where it is, Mr. Glazer. In a nutshell, it's quite straightforward. First of all, again, to the court, I apologize, and to counsel for having missed two Zoom status conferences. And we filed a response with an affidavit. We've had some computer problems in terms of scheduling, but that aside, I always take the responsibility for whatever happens. And again, I apologize to the court, and I apologize to counsel and to Mr. Mason too. Number one. Number two, I dispute their request for default and default judgment. Simply stated, they assert, and I don't know who wrote this, but they assert that they have fully prepared to officially litigate this matter, which is inconsistent with what's actually happened. And I point out to the court, for the purpose of having this motion denied and we proceed, that we've had two separate mediations on April 10 and May 22. Mediators Jason Bergwall. In both instances, counsel did not have a representative from Monti. As far as I know, they had no insurance representative of any kind, and they had no authority to negotiate mediation beyond their complaint. In other words, they couldn't address the counterclaim, which the claim exceeds the amount of the primary litigation. And again, not to discount missing the hearings, Your Honor, but we filed a response to the complaint, we filed a counterclaim, and we've attended the requisite mediations as part of the schedule. So that's the short of it. We requested to be denied. I've offered in my response to the court and counsel that any costs or attorney fees they've incurred to having attended these two prior status conferences, I will gladly myself, our firm, pay those costs for the inconvenience. And I'll answer any questions the court has if you have any. Thank you.
All right, I do not. Thank you, Mr. Glazer.
Thank you, Your Honor. I do just have a couple of points in response. Just as an initial matter, plaintiff's claim is for the principal balance of $35,265. The counter complaint says, exceed 25,000, not exactly 25,000. Never mind, I withdraw that. But I do want to point out that attendance at mediation, we had settlement authority at mediation. Just because we didn't reach an agreement at mediation doesn't mean that we weren't prepared for that. Further, there's been nothing addressed in regard to, we served discovery. There's been no response to discovery in this case. And again, without having seen, and with all due respect to Mr. Ingleson, without seeing the response, I'm not here to, I'll leave it up to the court's discretion on whether good cause was shown or not. in regard to the failure to appear. It's just a little bit frustrating from plaintiff's point of view that we're here at court on the scheduled date and times, and there's been no appearance on two separate matters, nearly 3 months apart, is a little questionable from the plaintiff's perspective. So I'll lend myself to the court's discretion on this one. Thank you, Your Honor.
All right, thank you. I did review the filings of both sides, and I am familiar with kind of the procedural standpoint that we're at here today. I will say, number one, I think that plaintiffs are entitled to some attorney fees for the time that they've spent appearing for the hearings. I think that's fair. I have no reason to doubt Mr. Ingelson's practice before this court for many years before I began as a judge here. And certainly in the 13 years I've been on the bench, Mr. Ingelson has never had an issue not appearing. So I have no reason to doubt that he has a legitimate reason for failing to appear, although I was surprised that it was twice in a row. That is certainly unusual for him in this court. But regardless, I as Mr. Glazer indicated, he's had to appear for 2 of these hearings, be prepared to go forward and take the time, and his clients have had to pay for that. So Mr. Glazer, I'm going to grant your request for attorney fees for having to have appeared at those prior 2 hearings. I would request that you submit an accounting to the court for that. The court is required under these circumstances when it awards attorney fees to make sure that they're reasonable. So I typically, take a look at that before I order a specific amount, and then based on your filing, I'll order an amount. And I will prepare an order reflecting that. And that order, Mr. Ingelson, will specify that those fees are to be paid by you, not by your client, because I don't find this anything that your clients have done to incur these fees. In terms of the report, yes, thank you. In terms of the default and dismissal of the counterclaim, the court doesn't find at this point that there's a legal basis to dismiss the counterclaim. The court, again, based on its acceptance of Mr. Ingelson's explanation for the failure to appear, finds that there is a good cause and that it would be improper to impose such a harsh sanction as a default or dismissal on that basis. So the court will deny those requests for relief, and I will put that into the order. Again, Mr. Glazer, I don't want your client to have to incur more fees for preparing the order.
No
so again, all I need from you is just the amount for the attorney fees, and then the court will provide an order of both parties on both those issues. I would like to discuss how to go forward from here, though, since we haven't been able to do that. Mr. Glazer, do you have any suggestions for scheduling to keep this case moving?
From the plaintiff's perspective, we would request there's 2 dates for us in mind: is a witness and exhibit exchange date. The initial disclosures do indicate that the counter complaint is going to require an expert witness, so we would want an expert witness report, witness and exhibit exchange date. Secondly, we would want a dispositive motion cutoff date prior to trial in this matter. Other than that, we have no pertinent dates moving forward that we would need.
Mr. Glazer, do you have any suggestions for timelines on those 2 issues?
Our office I would request 45 days we can either have it filed in 30 or filed and heard in 45 on a dispositive motion. Witness and exhibit list, whatever works for Mr. Ingelson will work for me. I'm not too picky on how much time we need for that.
Mr. Ingelson?
We certainly can do a witness and exhibit list as much as 14 days. I'm a little unclear about the dispositive motion deadline. I mean, I'm certainly familiar with that portion of any scheduling order. So whatever the court sets for that is fine with me. And in terms of witnesses to include experts, I recognize, of course, my own clients are experts, but absent the court ordering me to get another expert, I'll certainly include a witness and exhibit, including expert witnesses at whatever timeline the court sets. I mean, we could frankly be prepared for a trial easily in 60 days, just as a matter of calendaring only. Your calendar, meaning the court's calendar, and opposing counsel and mine. So we're ready to go.
All right.
I don't know whether you want us to take another run through mediation. Oddly enough, we received another email communication last Wednesday from the mediator about did he want us to do another go around. So, I mean, we're willing to do so if they want to.
All right, well, here's what I would propose. Obviously, the parties are free to agree to go to mediation at any point. I'm not going to order that right now. What I will order is that the parties exchange witness and exhibit lists within the next 30 days and that they identify witnesses that they would intend to elicit expert testimony from as part of those lists, whether that's your clients, Mr. Ingleson and Mr. Glazer, or somebody else. But that way everybody knows who maybe they may be seeking to qualify as an expert if we have a trial. Then I will set a dispositive motion cutoff for 60 days. That's to get it filed, not necessarily heard, but any dispositive motions we need to be filed within the next 60 days. And then what I would do is set this for a status conference either at about 90 days or at the time of a dispositive motion, whichever one comes first. Depending on the outcome of the motions, then maybe at that point we could talk about the court ordering further mediation. And if not, then we can set a trial date at that point. Mr. Glazer, on behalf of the plaintiff, anything further you'd like to request?
Nothing further, Your Honor.
Mr. Ingleson?
Nothing further, Your Honor. Are you going to include these deadlines in the order you're preparing, or do you want me to do that?
Nope, that will go out as a status conference order.
Okay, thank you. Nothing else.
Okay. The only other thing, Mr. Glazer, I'll put in just so we have a timeline out there. Also, any motions regarding disqualification, file those within that 60-day period as well. Just
no
so
problem.
that we have a cutoff for that. All right. Okay. All right. Thank you. That's all for today. All parties are free to disconnect on this file.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Yes, I do. So, I think FOC just emailed about that one too, asking if we could forward a copy of the written notice because they have it on administrative hold, but.
All right, we'll go on the record in Ferris versus Ferris. This is file number 2419904. This was set for a hearing today based on a notice that was received indicating that the parties did not previously had been put on hold for reconciliation, the 90-day hold back in April. And we got notice that they wanted to reopen the case. So this hearing was set today at 10:15. It's now 11:10. And no one did appear on that file. I'll set it for one more hearing date in 30 days. If no one appears for that, the court will close the case and dismiss.
Oh, it's fine. It's on.
All right, yeah.
Sorry. Not the angel place.
Okay, we have everybody connected, so we'll go on the record in Kent Family Farm versus Vaughn. This is file number 2419708. If I could just have all counsel put your appearances on, please.
Paul Slough on behalf of Kent Family Farm. Jeff Shimovitz on behalf of Benjamin Vaughn.
Drew Norton on behalf of the Rosemary Curatolo Trust and Michael Yonis.
Melissa Pronzales on behalf of Mertz.
All right, thank you. We're on the record today for purposes of a status conference. We had a motion hearing last month. I did see Mr. Shimovitz did file an amended complaint, or I'm sorry, amended cross claim. And so given the ruling last month, we set this for a status conference this month to kind of see how we may need to proceed. I guess my first question would be directed, Ms. Gonzalez, at you and your client. Where are your clients at after the ruling from last month? Has anything?
Well, I've been in contact with Mr. Shimovitz regarding completion of an appraisal. As I had indicated during the last hearing, my client has requested that he submit the fee to pay for the FHA appraisal so that we can complete a current appraisal of the whole property and then also the disputed portion. So that way there can be a determination made as to whether or not Mr. Vaughn is going to be responsible for any additional payment for this in exchange for a partial release of the mortgage for the disputed portion. Unfortunately, we haven't gotten very far with that. Maybe Mr. Shimovitz can give us an update as to his client's position, but it's putting my clients at a standstill as it relates to compliance with the court's order. In essence, forcing us to complete a partial discharge.
Right, Mr. Shimovitz?
Yes, sir. My client, obviously for budget constraints, wants to know what is the criteria under the evaluation for appraisal. This 2 whatever acre portion disputed property is part of the vacant portion of his mortgage property. He has a sizable home that's not in the disputed property, and basically over 75% of the acreage is not in dispute. So we feeling that even if FHA has some standards, we're at least entitled to know what they are in terms of what percentage of the current value would be represented by her quitclaim deed. And I'm hoping that my client will make a decision within the next 2 weeks.
I'm confused by what's being requested because Mr. Shimovitz and I have shared emails. I have advised him that FHA has requirements that if the loan to value after the release of this piece of this disputed piece is above 75%, then funds will be required by his client to be applied, or by my client will be applied to the unpaid principal balance as a condition of the approval. The starting point is getting the appraisal done, and I'm not certain why there has been no agreement to do that. This is a contract, this is an underlying mortgage between my client and Mr. Vaughn. He is the party that is responsible to be able to provide these values in order for my client to make a determination as to whether or not there is going to be funds that are required. So I don't understand the request.
Judge, if I may, there's another really obvious reason and benefit to have this appraisal done. It's going to give us a really important number that's germane to what's still pending and where we have to go from here, if we could ever have that discussion. If it's not obvious, it's the value of those two, at least one person's opinion of the value of those 2+ acres.
Right. So I don't know, Shimovitz, what's your client objecting to in terms of having an appraisal done? It seems like they would be in their best interest too.
I'm not disagreeing with that. We're very confident that the appraiser will bear out that his property without this 2 acres is more than the mortgage. But
okay,
it's just a practical problem of coming up with the appraisal fee.
Well, I certainly don't think that that MERS should bear the burden of paying for an appraisal for a lawsuit that it's essentially dragged into at this point. And to be candid, Mr. Shimovitz, the more that we put into this case, the more motions, the more hearings, the more everything that we have to attend, all of that is being applied to your client's mortgage. He's responsible for all these fees and costs that could potentially be interrupting my client's lien. So the further that we drag this out, he's essentially paying more in the long run. So I don't think it's MERS's position at all to pay for this. And if you do think that it's someone else's position to pay for the appraisal, then that's something your client can allege in this case, in this counterclaim.
He has alleged that the trust and Eunice, at the minimum, are responsible for his cost in defending. So if you're looking, I've got somebody else. Yeah, I've already got Mr. Norton's clients.
Yeah, which is in dispute because I researched it this weekend and I don't think you do. But sorry, Judge.
No, that's fine. I mean, Mr. Shimovitz, your client certainly can make that claim and they may or may not prevail on that. But that would be a money damage that they would be entitled to. I think at this point, we need to get the appraisal done. I think it's in your client's best interest for many reasons, including those that Mr. Gonzalez has stated, to get that done soon, quickly. And if they have to front that money, I think that's just, part of the cost of doing business in this claim. And they may be entitled to recoup that later as a damage. But certainly, I don't think Ms. Prinzala's client, I'm not in a position to order them to do it. And without finding liability on behalf of Mr. Norton's client, I'm not in a position to order them to pay it up front either. So,
Your Honor, I certainly respect your opinion, and I will take it back to my client.
Okay, so I'm gonna order that the appraisal take place within the next 45 days. And that Mr. Shimovitz, that your clients pay the cost for that with the caveat that that is a damage that they can claim and may be entitled to recoup later on.
Thank you.
But it needs to get done. So I'm gonna order that happen within the next 45 days. I'm gonna put that into the status conference order. And then I will set this for another status conference at 60 days. And let's see where we're at that point. Mr. Slough, you haven't weighed in. Do you have any?
I don't have anything really to add other than the court just may want to specify in that order that the appraisal must be pursuant to the terms of the mortgage or whatever it is that MERS is requesting be done. I mean, there's different kinds of appraisals, and I'm not sure, Ms. Gonzalez can speak to, what kind of appraisal this needs to be.
Yeah, so what I've indicated in some prior emails to councils is that it's essentially going to be a twofold appraisal. It'll be an appraisal of the entire property, and then the appraisal of the disputed portion of the property. So for obvious reasons, that way we can compare and then figure out whether or not it falls under or above the 75% mark. I have provided specific details in past emails to Mr. Shimovitz with regard to how to go about paying that amount. I can certainly do that again today after this call. But his client needs to contact my client directly and make that payment.
I guess I just want to make sure the order is clear, Judge. So it sounds like what Ms. Pranzalis is requesting is that they arrange the appraisal and Mr. Vaughn pay for it, rather than Mr. Vaughn arrange for the appraisal himself. And I guess I just want to make sure we're all clear on that.
That is correct.
Yes.
Okay. All right, I will put that into the order. Do we need more than 60 days for that status conference? I mean, are you all gonna need more time after the appraisal's done? Or will we be ready to talk about how to go forward that quickly?
I think we'll be ready.
Okay. Mrs. Prince-Alice, do you see any problems with that?
I don't foresee anything at the moment, Judge, but it is going to depend on how quickly Mr. Vaughn pays for this. So that's another thing that I certainly would like to determine today is a time frame. Because if we leave this call today and we say it needs to be completed in 45 days, and then he provides his, his fee at day 40, we're in a situation where it's not going to be completed on time. So I think that maybe if we can say that the payment be made within the next 14 days, so that way we can make sure that we can get this scheduled, and I will push my client to do as such as soon as they receive payment.
The 14 days seems a little bit short, but 21 days or 24 days would be a lot more reasonable.
This is starting to sound like delay to me, Judge, and it's costing money.
Well, I mean, I can put a time frame in there, but the fact is, if it's not completed within 45 days, then that's going to fall on Mr. Shimovitz's client. So whatever, I mean, I think 21 days is a fair amount of time. So I'll give his client 21 days. I'll put that into the order with the appraisal to be completed within 45 days. And then a status conference at 60 days.
Yes, sir.
Okay. All right, council, does anybody have anything else for purposes of today's hearing?
I'm going to seize an opportunity, Judge. Paul, if you haven't read the latest version of the cross claim, you better.
Was that, I mean, I was emailed, I never got it by mail, but there was one emailed?
Yeah, there's.
Well, I'll let you guys discuss this on your own time. That's not something I think needs to be on the record. So,
okay, sorry.
All right, so the parties will get this order along with the date for our next hearing, and everyone's free to disconnect. Thank you.
Thank you, Judge.
Thanks.
Okay, we'll go on the record and now in Hill versus Hill. This is file number 26-20420. And if I could have both counsel put your appearances on, please.
Reagan Richards and for Angel Anderson, Legal Services of Northern Michigan, on behalf of plaintiff Leslie Hill, who is seated behind me.
Courtney Stone on behalf of Edward Hill, who is incarcerated.
Okay. And Ms. Stone, do we have any arrangements for Mr. Hill to be present today?
I do not believe there's any arrangements for him to be present. I have been in contact with his family, so I have a full understanding of what's going on, and I can adequately represent Mr. Hill.
Okay. All right. So, Ms. Richards, what are you asking the court to do today with regard to the marital home?
Yes, Your Honor, we are asking for the marital home to be allowed to be put up for sale and sold, and then the proceeds put into an escrow account until the parties are able to reach a resolution or this court determines a division of the assets. The home was bought prior to the marriage in 2007. The parties were married in 2011. During the marriage, both parties made improvements to the home. The mortgage was paid off through a joint account where both parties contributed. The home was recently in foreclosure. It was able to be pulled out of foreclosure due to contributions from family and an IRA account. Those funds have dried up. There's currently neither party has the ability to make the payment of the mortgage right now. My client's only income is Social Security. Mr. Hill is incarcerated. So there's just no funds for the marital home. If it's not allowed to be sold, it will go into foreclosure.
All right. Who was on the mortgage for the home?
Just defendant is on the mortgage.
Okay. And is he the only one on the deed as well?
That is correct.
Okay. All right. Ms. Stone, what's your position?
So in speaking with my client's brother, there's a couple things going on here. So they had an appraisal done last week, Wednesday. They are still waiting for the information back from the appraisal. I believe that we are in agreement in selling the home. So that portion, we don't have an issue with. The issue that we have is basically how much the plaintiff is going to be entitled to based on him owning the home prior to the marriage. I would like to wait for the appraisal to come back. I don't know if the other side is willing to stipulate to waiting, with the understanding that we are in agreement that the home needs to be sold. Further, regarding the mortgage for this month, I have spoken to my client's brother. His brother and wife are willing to pay the mortgage this month so that we can have a little bit extra time, with, again, the understanding that they would be paid back out of whatever the funds come out to. So there's a couple things going on there, but that's where we stand at this point.
Okay. All right. So number one, I think we've got an agreement in terms of let's sell the house. I think it's fair to say, and Ms. Richards, it sounds like you're kind of on board with this too, is that the proceeds would be deposited into an escrow account for the court to determine, how much of those proceeds Ms. Richards, your client, would be entitled to based on, all the factors we know about in terms of the marriage. Ms. Richards, are you going to have any objection to the relatives paying for the mortgage payment for an additional month, and then them being entitled to reimbursement out of the proceeds?
Do you want to pay half or do you? My client is able to pay half of the mortgage for this month, and then the relatives can pay the other half. And then, are you okay with them being reimbursed? Yeah. And then they can be reimbursed for that half.
Okay. All right. Do you both counsel, do you think that you'll be able to agree, on a realtor and kind of the process of selling the home?
I do.
Okay.
Yes.
Ms. Richards?
Yes, I believe we can.
All right, so Ms. Richards, I'm going to ask that you just draft an order based on the motion indicating the parties agree to sell the home. That Ms. Stone's client through his relatives will pay half of, would that be the September payment, or do we still need to pay the August payment?
I believe it's the August payment has not been made yet.
I believe that's correct.
Okay, so half would be paid by the defendant through his family for the August payment, half by Ms. Hill for the August payment. Defendant's family entitled to reimbursement for their contribution, and then the funds to be proceeds to be deposited into an escrow account for determination by the court as to how to divide those proceeds.
And then just for clarity, would it be the home will be sold once the appraisal comes back? The home will be allowed to be put for sale once the appraisal comes back, or
is that what you, Ms. Stone, does your client want to do that before you even get it listed, or?
Yes, he'd like to at least have an idea of what the home is worth. And I think that's going to give us a lot more clarity. So if we could do that, even if we wanted to put off signing that order, if you send it over to me, we should get it back this week, he said.
Okay.
So if you want to put off signing the order for a little bit, or sending in a stipulated order, then we can get together after we get the appraisal back and then put a value on there.
Okay, so I will draft the order just that the home shall be put for sale immediately, and then we can get it to the court once we agree that the home can be sold.
Okay.
All right. Anything else we can address for your side today, Ms. Richards?
No, Your Honor, thank you.
Ms. Stone?
No, Your Honor, thank you.
Okay, thank you. All parties are free to disconnect.
Wonderful.
Thank you, Your Honor.
All right, we have both counsel connected. We'll go on the record in Crable versus Cornett, Woodward, and State Farm. This is file number 26-20340. If I could have both counsel put your appearances on, please.
Good morning, Your Honor. Michael Hanna from Morgan & Morgan on behalf of the plaintiff.
Your Honor, Charles Collison on behalf of State Farm Mutual Automobile Insurance Company. I'm in place today of Attorney Ryan Nasons.
All right, thank you. We're on the record today for, I believe, Mr. Collison, is this your motion to compel?
Yes, it is, Your Honor.
Okay, and then it just relates to Mr. Woodward, is that correct?
That's correct.
Yeah, I'm just observing this one, Your Honor.
Okay. So Mr. Collison, I did have a chance to look at your motion and basically you got no response from Mr. Woodward at all. Is that fair?
That's correct, Your Honor.
All right. The court notes for the record, the hearing was set for 11:45. It's now 11:50. I do not see Mr. Woodward appearing today, although he was provided with notice of the date and time of today's hearing. So Mr. Collison, I don't know if there's anything that you need to put on the record or if you just want to rely on your brief, I'll leave that up to you.
Yes, Your Honor. I don't have anything to add that's not outlined in our motion and brief.
All right, based on that and the failure of Mr. Woodward to appear today to challenge the motion in any way, I do find that you would be entitled to a motion to, or I'm sorry, an order to compel. Typically, the way that I treat discovery motions, my view is under the court rule, you have to file a motion to compel, get the order, and then if the order isn't complied with, then the court can issue sanctions. So, Mr. Collison, did you send an order with your motion?
I believe there was. If not, we can get one out today.
Let's take a look real quick. Okay, I don't see an order. So yeah, if you'll submit one under the 7-day rule. And then if you still don't get any response, then Mr. Collison, I just would anticipate your side filing a motion for sanctions on that basis. Is there anything else I can address for your side today?
No, Your Honor, I just indicate I did review the file. It doesn't look like we did send an order, so I will get one out. Thank you.
Okay, thank you. Mr. Hanna, anything you wanted to add today?
No, Your Honor. Thank you for your time.
Okay, thank you. That's all for today, and you're both free to disconnect.
Thank you.
All right, that concludes the court's morning docket. The court will be in recess until 1.